Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
Hello, listeners. Our topic today is key legal considerations in the use of portco data. That is data belonging to portfolio companies, or portcos for short. In an earlier podcast, we reviewed the technology contract issues in setting up a data lake. Those include software and data licenses, cloud service subscriptions, professional services contracts. Today, we'd like to talk about the fact that there's a lot more to big data, and we're going to use the example of portfolio company data to do that. My name is Julian Dibbell, and I'm your host. I am a senior associate in Mayor Brown's Chicago office with a practice focusing on technology transactions. I'm joined today by Libby Raymond, who co-leads our global corporate and securities practice, and Brad Peterson, who leads our technology transactions practice. Brad, let me start with you. What do we mean by portfolio company data? What are we talking about here?
That's a good question, Julian. Technology and data have always been key strategies for private equity and for other investment funds. And some of the funds have long been leaders in math and big data and analytics for trading. One of the potentially rich areas for these private equity and other investment funds is to leverage the operational data at the companies where they are investors, the portfolio companies, or what we call portcos for short. The funds often get some of that data in board packages when they have directors or observers on the board, or reports generated under investment agreements, and they may have access, if they ask for it, to considerably more operational data, plus all the data that they have been maintaining to make smart investments in the portfolio company. So, portco data from one portfolio company might help a fund decide whether to invest in a supplier to the portco or some other company.
Okay, so how does this work? The fund uploads the portco data into its data lake, probably at a hyperscale cloud provider, and then runs analytics. Is that it?
Yes, exactly. But as it turns out, it's not that easy. The fund has numerous legal obligations as to its collection, handling, storage, use, processing, and disclosure of portco data.
Okay, so that's sort of the first hurdle. So let's look at that. What are some of those legal considerations? Libby, as a leader in our corporate and securities practice, what do you see there?
Well, depending on the structure of the investment, private equity funds may have both contractual and fiduciary duty obligations to their portcos. These concerns are heightened where the fund holds less than 100% of the portco and there are other investors involved. Investment agreements often provide access to information about the portco, but then require the fund to keep the information confidential and use it only to manage the fund's investment in the portco. Fiduciary considerations may arise when the fund designates a director, because directors, at least directors of corporations, owe fiduciary duties to the portco and its equity holders. Fiduciary duties include the duty of care and the duty of loyalty. These duties may limit the extent to which portco data can be used. These duties depend on the type of entity involved, the jurisdiction of organization, and the exact terms of the governing documents and investment agreements under which the fund is making its investment. For example, waivers of fiduciary duties are possible for Delaware limited liability companies and Delaware limited partnerships, but not for Delaware corporations. Another group of problems is under the securities laws. Securities laws prohibit insider trading, traditionally defined as the purchase or sale of securities on the basis of material non-public information. There may be material non-public information in the portco data. Funds generally have well-developed policies to identify material non-public information and exclude it from the data lake or restrict access. Of course, these policies get more difficult when vast amounts of data are flooding into the lake. A third area of concern is antitrust. Antitrust laws restrict sharing of certain types of competitively sensitive information between competing portcos. For example, sensitive areas might include current or forward-looking strategic plans, opportunities, target markets, or investments. It can include pricing information, marketing plans, or terms of trade. It can include forward-looking cost or margin data.
Wow. Well, that's a lot to manage just in the corporate area. But Brad, what else should listeners consider?
Well, there's quite a lot also in the data and the intellectual property space. Regular listeners to this podcast will, of course, know that data privacy and data security laws impose requirements on storage, processing, use, and transfer of various types of data, especially personally identifiable information and various types of sensitive data. For example, data with military applications and so forth. But another area that we haven't talked much about in the Tech Talks podcast is that e-discovery laws may require the fund to produce data relevant to its uses of portco data, which may only be relevant or possible if the fund has retained that data. Also, e-discovery laws may require the fund to produce data relevant to its uses of portco data. That production may only be possible if the fund has actually retained that data. Funds need information governance and data governance policies appropriate in the context of the kinds of claims that Libby described. And that's a particular challenge because the machine learning models and AI technologies that funds use may not produce a record to explain their decisions. So the data lake needs to be built to be defensible in court, and that means a great deal of advanced preparation, building the data lake in a way that will allow the fund to demonstrate that it complied with the obligations that it has. A third area, of course, is intellectual property, and we've noted that IP laws generally don't apply to data specifically, but when we're talking about portco data here, we're also talking about things that are protected, for example, by copyright. Primary area, though, is trade secret protection. And you could lose trade secret protection for portco data, maybe not only for the fund, but also for the portco, unless the fund makes reasonable efforts to maintain the secrecy of that portco data and meets the relevant legal obligations. So the fund needs a trade secret protection program that includes the right information security measures and access control, plus appropriate contractual frameworks whenever sharing portco trade secrets with third parties like the hyperscale cloud providers that you mentioned. And, in closing, just generally, there's a really good reason to focus on how to protect the great ideas that go into this entire project of leveraging portco data and how to have the needed licenses for third-party data and technology.
Well, that's quite a lot. Before we dig into any of those points, let's spend a few minutes on how companies handle compliance. Libby, where do companies even start with that?
Well, the starting point is understanding the rights and compliance requirements that will apply to portco data. The following types of obligations stand out. First, what rights does the fund have to access and use portco data under their investment agreements, NDAs, data licenses, and other contracts with portco? What are the limitations? Second, what information will a director have the right to by virtue of their status as a member of the board? Are there statutory rights to books and records as an owner? What fiduciary duties does the fund have under applicable corporate law for that information? Finally, what policies does the fund have to avoid material non-public information and other data that cannot be used for trading?
Okay, and then how does the fund go about complying with those requirements?
Well, compliance requirements need to be addressed, even starting at how the data is ingested into the data lake, how it's stored in the data lake, and how it's removed from the data lake. So, for example, the fund might have software that de-identifies and anonymizes any personally identifiable information before it's ingested into the data lake, and then controls within the data lake to prevent re-identification or de-anonymization. The data lake may have access controls that only permit certain users to copy out data for certain purposes. And those permitted purposes might be there to limit the investment decisions and the other actions that can be made using the data. So you'd have an interface that requires appropriate credentials and also people to indicate the uses that they'll put their data to. Third, you can build the data lake with data governance and data security protections. The data lake should have technology to enforce those use restrictions that we've talked about, to create a record of data provenance linked to the data-specific guidance. Where did the data come from? To protect the metadata that courts may later ask about, to create a sort of a truth file that you can later use in litigation, and to explain the analytical outcomes. And then generally, you also see data security, confidentiality, access logging, and other requirements in the analytics engines that are built as part of the data lake to derive the insights that are being used for trading.
Libby, you mentioned that funds may have fiduciary obligations to portcos, and that those can require the fund to use portco data only in connection with managing the fund's investment in the portco. Fiduciary obligations are something we all learn about in business law in law school, and they've been around for a while. But it sounds like in some ways they the way that they apply to data use takes on new meaning in the digital age. What can you tell us about that?
Yes, as I said earlier, fiduciary considerations can arise for the fund when it designates a director. This concern is heightened where the fund is only one of several investors or owners of the portco. As we all know, directors owe a duty of care and a duty of loyalty to portco and all of its stockholders, not just the fund that the director has been designated by. Included in the duty of loyalty is a duty of confidentiality, which requires a director to maintain the confidentiality of sensitive information that he or she learn as a result of being a director. Also included in the duty of loyalty is the corporate opportunity doctrine. This doctrine restricts directors from personally benefiting, including benefiting their fund, from an opportunity that belongs to the corporation or the portco. There's nuance to this. If the fund designates an observer only, the observer does not owe fiduciary duties under Delaware law. Similarly, absent unusual circumstances, funds don't owe fiduciary duties merely as a minority stockholder. Some of these fiduciary duties can be waived, but others can't. All this depends on the jurisdiction and form of the entity and the exact terms of the governance documents under which the fund is investing. These documents could include the portco's charter, bylaws, investor rights agreements, LLC operating agreements, or limited partnership agreements.
Now, those sound complex. What about the contractual considerations?
Well, when you have all those documents, all of which were written without this use in mind, they were when you open these documents up, it's always clear that no one was thinking about a fund using the portco data as they wrote them. So they require some interpretation. But portcos may require directors and observers to sign confidentiality agreements. Governance agreements may provide access to books and records, and some of those might be broad enough to cover operational data. Some of them provide relatively broad, license terms. It's also very, very common and almost instinctive for the lawyers for the corporate lawyers to restrict the use and disclosure of portco data or restrict the disclosure and state that the data can only be used for the one purpose it was provided for, such as managing the arrangement. Another notable term that you may see in a governance agreement and could be very helpful is an express right for a director or a board observer to share the portco data that that director or observer has with the fund. And waivers of fiduciary duty in governance agreements with portcos where permitted under applicable state corporate laws could avoid many of the complexities of fiduciary duties generally.
I agree that a data sharing agreement would be helpful, but it can present its own conflicts of interest for any director. In adopting a data sharing agreement, it may not be appropriate for the director to participate in the board's discussion and approval of that agreement. Portco may have a contractual right to require recusal of that director, and absent such a contractual right, the director should consider whether recusal from the board discussion would be appropriate. The designee should refrain from voting on the matter if there's a conflict of interest, as the fund's interests likely would not be shared by the other stockholders of Portco. These are complex areas, and there's really no one-size-fits-all approach because of the divergent laws and agreements. We believe that you actually need a deal summary for every investment on these topics, which ideally is incorporated into the data lake access system. But of course, agreements can be as much a solution as a problem. You can have formal data license agreements or data license clauses in stockholder agreements or other participation or non-disclosure agreements.
Okay, excellent point. And so you've said the magic word data license agreement, which brings the discussion solidly into our wheelhouse here at Tech Talks, which is technology transactions. Brad, so you and I, as technology transactions lawyers, are very familiar with data licensing deals. And hearing them mentioned here, my mind immediately starts running through all the standard clauses, scope of data, permitted users, permitted purposes, limitations of liability, term and termination, and so forth. And gets me wondering how those play out in the context we're talking about here. But I guess you've already thought these through, Brad. So why don't you give us a rundown of what a fund might want to see in a data license?
What the fund would like to see is a broad exclusive license that includes a commitment to provide timely, accurate, anonymized data. And they'd like the commitment to be to have that data formatted in a way that ingests easily in the data lake. The fund would also like to see that data provided at low cost or no cost in perpetuity. The fund's wish list might include indemnities against third-party claims. But that's not practical. Even aside from the fiduciary duty problems that Libby mentioned, portcos generally don't have the people, the processes, or the technology that portcos would need to be successful in the data licensor business. In fact, portcos are probably better set up, for the most part, to prevent their operational data from getting outside of their systems than they are at providing copies of their operational data. So, a fund that wants to monetize portco data needs to make a targeted ask in its license agreement. That targeted ask might include, for example, a right to copies of specific data sets in the format that those data sets exist, or some other format that's easy for the portco to generate. The license agreement might include limitations permitting use only by a limited group of people at the fund for a narrow set of purposes, perhaps on a limited set of systems, such as the authorized data lake. The license agreement on the liability front might provide that the data is provided as is, and the fund might actually need to make promises to keep the portco's data safe and may need to accept the risk of liability if the fund breaks those promises or uses data beyond the license scope. There may also be reasonable compensation from the portco to the fund, and that may be in dollars, or it may be a return of analysis of the portco data in ways that may be useful to the portco.
All right. Well, to summarize, this is a complex analysis, and it's not a simple matter of pulling the data into the lake and just letting the data scientists work their magic. As we close, Libby, where does a client begin with this process?
So if we're talking to a fund about using portco data, the first step should be to ask several key due diligence questions about the portco. First, jurisdiction. What jurisdiction's laws govern the portco? Delaware is common, but it may be another state, it may be a foreign country that we're looking at. What's the entity type? The type of entity will determine whether you can waive fiduciary duties, among other things. So is it a corporation? Is it a limited liability company? Is it a limited partnership? Is it a control or a minority investment? Does the fund own 100% of portco, or does it own only a controlling or minority stake? What are the fund designees? Has the fund appointed actual directors or only observers to the board of portco? Some portcos may decide that it's smarter to appoint only observers, because then they'll have more flexibility to use data. Is there a fiduciary duty waiver? This applies for limited liability companies and limited partnerships. Are there information sharing agreements in the governance documents that explicitly allow directors and observers to share information with their fund? Confidentiality provisions. What, if any, express disclosure or use restrictions apply? Is there a corporate opportunity waiver in the governance documents? It's a very common provision for private equity funds to obtain, but it's important to make sure it's actually there in the documents. What other contractual provisions will apply? Are there other terms that bear on the use of non-public information? For example, are there license or other data sharing provisions in the basic governance documents? With the answers to these questions, we can work to develop a strategy that complies with the legal requirements, and where needed, obtain desired rights to go beyond the legal requirements.
Well, thank you, Libby. Brad, any final thoughts?
Julian, I think this dive into big data for funds using portco data is a great example of the complexity that we often find in data lake projects. And our Tech Talk team generally focuses on the questions, the professional services, the cloud services, the data analytics, things of that sort. But in any data lake project, it's well worth considering what other legal disciplines need to be involved to make sure that the entire project is both compliant and capturing as much value as it can for our clients.
Well, thank you, Brad. And thank you, Libby, for all of your insights. Listeners, if you have any questions about today's episode or anything else related to technology transactions and the law, please email us at techtransactions@mayorbrown.com. In particular, if there is a topic you would like to hear us devote an episode to, please let us know. Thanks as always for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.